is a warning to members of the public in Ontario, Canada, concerning lawyer misconduct and how easy it is for lawyers to escape legal consequences with the assistance of the Ontario legal industry supporting them. The story identifies how an injustice was brought into being by a lawyer using disinformation to gaslight the Brampton court, and for over a decade, the case lawyers have gotten away with code violations that have obstructed justice. In 2012, the case Edwards v. Morneau-Sheepell took place in Ontario's Brampton court, presided over by Justice Blaby. The civil action came about as a result of a Morneau-Sheepell guidance counsellor malpractice. The counsellor, Catherine Heyman, unethically defamed Bruce Edwards' name, and to the point, it destroyed his family and put his life at risk. A direct result of the aftermath, Heyman's defamation was so severe, Bruce Edwards had no other choice than to represent himself in court. Not an ideal situation, but in light of him having irrefutable evidence that surpassed the liable legal test, the litigation process should have been able to proceed seamlessly. However, from the outset, Sheepell lawyers impeded legal process by refusing to provide Catherine Heyman's contact information. Obstructing what is normal legal process effectively prevented crucial documents of service from being legally served on Catherine Heyman, and so the litigation came to an abrupt standstill. Having created deadlock, Sheepell lawyers then insisted, if any litigation was to commence, it should be directed at Morneau-Sheepell, and not their guidance counsellor, Catherine Heyman. Following legal code, this demand appeared entirely unreasonable, but given it was going to be the only way forward, Bruce Edwards felt compelled to give in to their demand. But that said, it still felt nonsensical to be targeting Morneau-Sheepell, because at the end of the day, it would still be Catherine Heyman who would have to pay the ethical consequences for her malpractice. Confused as to why the lawyers would take this stand, Bruce Edwards, an ex-private investigator, became suspicious and as a result, commenced an investigation to uncover the lawyer's motive incentive. But immediately, he ran into verification issues. Indeed, such was the confusion clarifying Catherine Heyman's existence, the case hearing date came along without Bruce Edwards being able to verify any of the evidence he'd been able to obtain. Baffling the situation further, none of his investigation findings appeared to be consistent with any of Morneau-Sheepell's factum statements. So what was going on? Just so we are clear, the correct position concerning factum statements being factual is verified by legal code and a multitude of lawyers online. Two of which being Ms. Carolina Beeler and Mr. Robert Bell. They confirm in a lawyer's duty to the court. Lawyers are under a positive duty to make full disclosure of all the binding authorities relevant to a case. This means that all such authorities on point must be brought before the court, whether they support or undermine the position being argued by that party, even if opposing counsel has not cited such authority. This element of the duty includes drawing a judge's attention to any legal errors which have been made so that they can be corrected. This acknowledgement of legal duty is clear, and the professional validity of Sheppell's factum seemed assured, by the fact the lawyers overseeing Sheppell's defense were Morneau-Sheppell's senior in-house lawyer, Ms. Roslyn Cogan, and lawyer in court, Ms. Pamela Mills, from the Toronto-based company, Aird and Burles. Beyond doubt, their involvement gave the impression the case was being overseen by two high-profile lawyers who clearly knew legal procedure and what was ethically expected of them. So, the evidentiary disconnect Bruce Edwards was experiencing was baffling, and this would have us go back to the initial question again. If the investigated facts were not lining up, what was going on? This question was to be answered in the fullness of time, but it came in the form of a self-represented person's worst nightmare. So, let's look at what happened in court. On the day of the case, even before he would allow the case to commence, Justice Blaby had cause to question a glaring omission in Sheppell's defense factum. And that being, the conspicuous absence of Catherine Heyman being named to be defended. The legal issue of course being, if failing to specify who the defense factum information is defending, it's not actually defending anybody, and so being groundless, the case would have to be struck out for being frivolous and vexatious. Clearly not wanting that to happen, Sheepell lawyer Pamela Mills sought to appease Justice Blaby by assuring him absolutely, all the information in Sheppell's factum, although not naming her directly, was nonetheless entirely pertinent to Catherine Heyman. Seemingly happy to accept Pamela Mills' legal word, Justice Blaby allowed the case to proceed. So, following established court protocol, Bruce Edwards presented his compelling evidence that identified Catherine Hayman's actions did meet the legal criteria supporting his claim of defamation. Indeed, his evidence was so compelling in relation to the defamation legal test, Pamela Mills did not even bother to dispute the decisiveness of his evidence. Instead, to counter defamation law, Pamela Mills quoted unrelated legal precedents and some member ethics of the Canadian Licensing Authority, the OACCPP. Most arguably, with all her statements being unsupported, this as a defense should not have been able to defeat a civil law, but the outcome was, Morneau Shepell won the case over a self-represented layperson. Clearly it was an education to find out that laws in Ontario can be evaded by unsupported lawyer statements, but more thought-provoking was the illegality of the judgment left in place. With numerous Canadian licensing authorities identifying that the Brampton court judgment did not conform to their legislation, the investigation into the veracity of Shepell's legal statements continued, and in the fullness of time, the bewildering investigation discrepancies all started to make sense. Indeed, the legal position was now unmistakable. The investigation had provided a wealth of evidence that revealed either the investigation findings were all totally wrong, or Morneau Shepell's legal defense was entirely fabricated, and the situation had to be one or the other. As was then, and still is now, the investigation evidence is legally compelling, Shepell's case was fabricated. However, after years of trying to get the disinformation offence addressed, numerous officials approached within the Ontario legal industry have still not seen fit to hold the errant lawyers, Cogan and Mills, accountable for their disinformation obstructing an official proceeding. This pervasive inaction within the legal industry not only undermines the effectiveness of our courts, but also leaves various industry echelons seemingly complicit in endorsing lawyer fraud, and this despite the existence of codes mandating professional integrity. Identified by legal code, this case contains a serious misconduct issue and egregious, failing to address the wrongdoing appears nothing short of tacit approval from within the legal community. This case identifies, here in Ontario, lawyer misconduct can be ignored with alarming impunity for lawyers and at the cost of honest public litigation. But let's now assess the disinformation. You'll remember, this case was initially brought about to address Catherine Hayman's unethical malpractice, and her importance to the case was made clear by the judge insisting lawyer Pamela Mills assure him, before commencing the case, Shepell's factum was pertinent to Catherine Hayman. Indeed, Catherine Hayman is mentioned several times in the judge's endorsement that ended up siding with her conduct. So, she clearly played a large part in the case. Except, she didn't. Noticeable by her absence, Catherine Hayman did not attend court to give any evidence in support of Shepell's so-called defense of her, despite Pamela Mills assuring the judge that Shepell's case was all pertinent to Catherine Hayman. And nor did Hayman offer any written defense to counter Bruce Edwards' allegations against her. The stark reality was that Catherine Hayman didn't put forward any statements in support of anything stated in Shepell's factum. This meant that for all intent and purpose, Catherine Hayman took absolutely no part in any of the proceedings whatsoever, despite Pamela Mills confirming to the judge that she was entirely pertinent in support of Shepell's factum statements. Lucidly, with the absence of any supportable facts, Shepell's defense was nothing short of a collection of irrelevant random statements. However, the judge failed to comprehend the legal significance of Shepell's factum not upholding the basic mandatory legal code that would have it provide material facts. Consequently, Justice Blaby's endorsement is now left on legal record siding with the actions of a person who was not named to be defended, who was not in court, who was not relatable to any of Shepell's factum statements, and who did not refute any of the accusations made against her. Thus, in Catherine Hayman playing no part in the case, her ability to win it can only be interpreted as extraordinary beyond all reasonable comprehension. So having unconventionally accepted Shepell's fraudulent factum pleading, which was not remotely accurate as to the facts, what does integrity duty now require of Justice Blaby to put right the wrong and protect the victim of Shepell's disinformation? The mandatory legal remedy to address Shepell's lawyer illicitness is well defined in Rules 21.1, 3 and D and 25.11. They empower the court to strike out pleadings that are scandalous, frivolous, or vexatious. The rules state, a pleading that demonstrates a complete absence of material facts will be declared to be frivolous or vexatious. Pleadings that are irrelevant, argumentative, or inserted for color or that constitute bare allegations should be struck out as scandalous. The same applies to a document that contains only argument and includes unfounded and inflammatory attacks on the integrity of a party, and speculative, unsupported allegations of defamation. With indisputable evidence identifying Scheppel's case was entirely fabricated, it must be struck out to accommodate the legal remedy imposed by code rules or make untenable nonsense out of legal code. Indeed, it is said, if conclusive evidence proves an act of fraud did obstruct justice, the perpetrator of the fraud is required to be held criminally accountable for obstructing justice. On this occasion, that would have to be lawyer Pamela Mills, for signing off on Scheppel's factum. Or do we have to accept, this experienced lawyer just did not do her diligence as to the facts? Regardless of any excuses for presenting disinformation, the conclusive evidence identifies that the situation doesn't get any more serious, especially for lawyers who should know better. Legal code states, a lawyer must not knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence. Seemingly accommodating the mandatory rule requiring lawyers to identify an on-point authority to the court, in Scheppel's factum, Pamela Mills provides the court with evidence of the standards of practice for members of the Ontario Association of Consultants, Counsellors, Psychometrists and Psychotherapists. The OACCPP for short. The OACCPP was the only licensing authority named in Scheppel's factum, so plainly, the judge had to assume this was the applicable on-point authority required by code to be identified. Thus, the judge was influenced by the OACCPP member ethics legislation, which was said to be legally pertinent to Catherine Hayman. For the record, the OACCPP is a reputable Canadian licensing authority, except quoting their member ethics in this case was not legally permissible, and for a very good reason. As confirmed by the OACCPP, their member ethics are only applicable regarding the actions of their members, and Catherine Hayman was not, and never had been a member of the OACCPP. So OACCPP member ethics had no place in misdirecting in a case that legally required material facts concerning Catherine Hayman. This realization left the position, by lawyer Pamela Mills including and thus, implying OACCPP member ethics were legally applicable to the case. Once again she successfully departed from presenting, as legally required of her, material facts. And so, was her departure from the truth legally acceptable? Rules Chapter 5(6), the lawyer must take particular care to be accurate, candid and comprehensive in presenting the client's case so as to ensure that the tribunal is not misled. In Pamela Mills including OACCPP member ethics, Scheppel's case cannot legally be interpreted as being accurate, candid, or comprehensive and thus, it is not possible for her not to have breached her duty to the court, and especially with the outcome, the court judgment endorsement makes ethical reasoning in support of Catherine Hayman. However, the legality of Pamela Mills' factum submission gets significantly worse. In Bruce Edwards' meticulous investigation, every facet of Scheppel's nonsensical factum was scrutinized, leaving no stone unturned and the unequivocal findings lay bare. Scheppel's case was a concoction of pure fantasy. Indeed, it was an incredible gamble by the lawyers involved, because it is blatantly clear that their entire case relied solely on their false statements not being investigated. This of course begs the question, how many times had the case lawyers, Kogan and Mills, misled courts in the past, and since winning the case in 2012? To understand the construction of Scheppel's case we need look no further than the old saying, there is one constant when a company is caught doing something wrong, the cover-up is always worse. With this in mind, let's try and understand why Pamela Mills introduced a licensing authority of no legal pertinence to anybody in the case. Could it have been because, as the investigation revealed, Morneau Scheppel's guidance counselor, Catherine Hayman, was not licensed to practice here in Canada? Well, by presenting OACCPP member ethics, that certainly gave the impression Catherine Hayman was licensed to practice here in Canada, but that was not a material fact, and so by introducing flagrant disinformation, the court was misled, but to what degree? Turning into an international investigation, it was discovered, in fact, Catherine Hayman was licensed, but her authentic licensing authority, which rules dictate should have been disclosed to the court, was in fact the Texas State Board. This authority is based in Austin, Texas, and not Canada where her malpractice took place. But the real value of Pamela Mills' failure to identify the authentic on-point licensing authority to the court becomes apparent after the commencement of a complaint inquiry that Bruce Edwards initiated with the Texas State Board into Catherine Hayman's unethical conduct. He provided the board with the same information as was presented to the Brampton court. In 2014, a full 2 years after the Brampton court judgment, the Texas State Board inquiry finally concluded, and in a public statement to Catherine Hayman, it made clear, verbatim, the board, however, advises you to adhere to and comply with all board rules, specifically, Code of Ethics. Unquestionably, the board would lack any legal basis to criticize or instruct Catherine Hayman to explicitly adhere to board Code of Ethics if she had already been in compliance. In this context, her malpractice was undeniably affirmed by the authoritative body that Sheepell lawyers deliberately concealed from the court. And so the necessity for the board to caution Catherine Hayman indicates, beyond doubt, Bruce Edwards' liable claim was legally valid and legitimate and was foiled only by lawyer deception. By violating her positive duty to make full disclosure of the binding on-point authority, Pamela Mills not only compromised the integrity of the proceedings, but also hindered the presentation of additional crucial information that could have further substantiated the strength of Edwards' case. If we add Pamela Mills substituting the authentic on-point authority, then her obstruction of justice becomes very serious because it is clear, if her factum had not been investigated, Pamela Mills' fraudulent submission would not have been discovered, and her dishonesty would have been able to thrive unabated. Indeed, the situation is so legally serious, it inevitably must beg the question, exactly how many other Ed and Burles cases can be said to be legally unsafe, because of Pamela Mills' involvement? As confirmed by code rules, Pamela Mills' participation in this case has undeniably brought about an unacceptable injustice. But what must be more disconcerting is the inadequate response from the Ontario legal industry in addressing her egregious misconduct. In a system where integrity appears to hold diminishing significance, the industry's failure to act against a lawyer engaging in code violations is nothing short of outrageous and raises serious questions about the commitment of the Ontario legal industry to its fundamental principles. Code, Chapter 5, Relationship to the Administration of Justice. A lawyer should not hesitate to speak out against an injustice. Spanning more than a decade, in a damning indictment of the Ontario legal system's moral decay, key figures within the realm of justice, including officers of the court and esteemed officials, have been inundated with pleas to hold the egregious misconduct of lawyers Roslyn Cogan and Pamela Mills accountable for their blatant obstruction of justice. Sadly, these calls for action have all fallen on deaf ears, with those entrusted to safeguard the sanctity of the legal profession shamefully neglecting their solemn duty to confront and condemn injustice without hesitation. The Ontario Law Society is on record shamelessly shielding these errant lawyers, dismissing all wrongdoing by them, despite irrefutable evidence from their own code that unequivocally exposes their malfeasance. This egregious failure to uphold the principles of justice raises serious questions about the integrity and accountability of the Ontario legal industry, and now most arguably, enough evidence exists to insist that issues of injustice require being policed more stringently by public bodies, and not by an apparent biased law society whose only concern appears to be to safeguard the interests of lawyers. Indeed, there appears an apparent readiness to protect lawyers, regardless of them willfully obstructing justice by use of disinformation, that effectively gaslights the court. The failure of the industry to hold the lawyers in this case accountable is not only a disservice to civil litigation, but it also undermines the fundamental effectiveness of the courts. Beyond argument, the public should not be burdened with the necessity to actively investigate and verify the accuracy of statements made by opposing lawyers in court. It undermines the very essence of a legal system built on trust and accountability. Indeed, it is clear that a continuing pattern of misuse of our courts by lawyers can only serve to undermine the rule of law, so action is required to address all court injustice. It is clear that to restore faith in the legal system, instances of disinformation that obstruct justice must be addressed promptly and decisively. This not only protects the rights of individuals directly affected but also upholds the credibility and integrity of the legal profession as a whole. The mental cost of injustice is to be discussed on this channel, along with the pitfalls of self-representation, in a 2024 podcast. If you would like to be notified of the date and times, please subscribe to this channel. For now, thank you for taking an interest in this case history, and may we wish that you never have to go through this devastating experience.